Slavery in the United States did not arise by accident. It was not an inevitable part of human society, nor was it simply a continuation of ancient practices. It was a carefully constructed legal system, engineered, defended, and justified by some of the most powerful jurists and lawmakers of the 18th and 19th centuries. In this video, we're going to take a look at one of the most pivotal moments in that history, the Somerset v. Stewart decision of 1772, where an English court acknowledged that slavery was so contrary to natural law that it could only exist if a government explicitly wrote it into law. But after that decision, instead of abandoning slavery, the slaveholding colonies responded in a very different way. They sought to remake the very idea of natural law itself. To protect the institution of African bondage, they created a racist intellectual framework, one that declared people of African descent naturally suited for enslavement and white people naturally suited to rule. These ideas didn't just shape the law, they shaped the society, the culture, and the entire worldview of the antebellum South. So today we're going to walk through how slaveholding jurists twisted natural law to defend slavery, how they built a white supremacist ideology to support their legal arguments, and why understanding this matters for how we talk about slavery and its legacy today. So in Somerset v. Stewart, a man, an enslaved individual named James Somerset, was purchased by Charles Stewart in Boston. Stewart brought Somerset with him when he returned to England in 1769, and in October of 1771, Somerset escaped but was recaptured in November. An application for a writ of habeas corpus was made on Somerset's behalf, and he appeared before the Court of the King's Bench, which had to determine whether the imprisonment was lawful. The judge, Lord Mansfield, declared Somerset to be free, stating in his opinion, quote, "The state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law. It is so odious that nothing can be suffered to support it, but positive law," end quote. So what does that mean? That according to common law, slavery could not exist without a law allowing it to do so, because it goes against the laws of nature. So what was the slaveholders' answer? Because now you have to understand, this was a big problem for the slaveholding colonies, which would eventually become the slaveholding states, as only one, Georgia, had a positive law allowing slavery. And for the record, this positive law only existed because at one point Georgia outlawed slavery and then sought to reinstate it, so they needed a positive law to allow slavery to begin again. So the answer for the slaveholders, for these slaveholding jurists, was to declare and attempt to prove that slavery was not against the law of nature. Instead, slavery was the natural condition for Africans and people of African descent. And since it was natural, no positive law was required for its existence. The slaveholding jurists were careful to make sure there was a clear distinction between the state of nature, as described by men like Locke and Hobbes, and the law of nature. They agreed that in a state of nature, everyone was born free and equal, but they did not believe the law of nature required that everyone remain in such a state. So what would allow one to take the freedom away from another? If they could prove that enslavement was good for the enslaved, if it bettered their condition, if slavery was in fact a better place for someone to be, then of course, to them, it was not contrary to the law of nature. They also had to prove that slavery within the same race was in fact contrary to the law of nature, or else why not just simply enslave poor whites? They would create an argument that the right to personal liberty was not a natural right for all people, but only for those races to which liberty produced happiness and worked to perfect them. So to this end, slaveholding jurists defined the law of nature as that, when applied to man in his intercourse with his fellow man, is the obligation to shape his course as to attain the greatest happiness and to arrive at the greatest perfection of which his nature is susceptible. Consequently, whatever interferes with the attainment of this happiness and perfection does violence to the law of his nature, and whatever promotes his happiness and perfection is sanctioned by the law of nature. So if it's good for him, it falls within the law of nature. If it's bad for him, it is against the law of nature. So if the slaveholding jurists could prove that Africans were inferior to whites and needed to be enslaved to better their condition, then it was, in fact, natural and follows the natural law. And here is where they made sure to protect whites from enslavement by other whites. Since the enslavement of a man or a race by another race that is physically and intellectually equal would do nothing to promote their happiness or to perfect them, it simply could not happen. In other words, there was nothing a white person could learn or be perfected by being enslaved by another white person, since they were in fact equals. So equals could not enslave each other. To make this legal position make sense, they had to create a racist and white supremacist worldview which looked at people of African descent as inferior and created by God to be servants to the white race. They asked what was the nature of the African race. They recognized in people of African descent that they were in fact human and endowed with reason, will, and accountability, but these slaveholding jurists believed these attributes could only be developed in a state of slavery. They used racist pseudoscience to hold that Africans were naturally suited to labor because of their dark skin, with many scientific professionals describing the physical characteristics of people of African descent as closer to monkeys than to Europeans. They believe that no African race ever produced anything of value, never created a theological system, discovered an alphabet, nor made the least step in any science or art. Any achievements on the African continent, such as the pyramids in Egypt, were attributed to Caucasians or races they believed were derived from Caucasians, such as Arabs. If Africans played any role in any creations in Africa, it was only in their role as slaves to the Caucasian races, who they believed actually built these monuments. So being both physically and intellectually inferior to the white race, the slaveholding jurists believed that when an African had the fortune to be enslaved by the superior white race, he was, without a doubt, fixed in such a state of life that was most agreeable to his capacity. What Somerset v. Stewart exposed was simple. Slavery had no foundations in the law of nature. It could survive only through explicit, deliberate human choice. Faced with this truth, slaveholding jurists chose not to dismantle slavery, but to rewrite reality. They created an entire legal and philosophical system founded on white supremacy and designed to portray slavery as beneficial, natural, and many times even God-ordained. And worst of all, those ideas became the backbone of the racist caste system that shaped America before, during, and even long after the Civil War. Understanding these arguments matter. It shows us that the horrors of slavery weren't just physical, they were intellectual. African slavery required lies, pseudoscience, racism, and white supremacy. It required entire generations of lawmakers, judges, theologians, and academics to build a worldview in which one group of human beings could be declared naturally inferior and destined for servitude. And when we study these legal justifications, we see how clearly and how deeply white supremacy was woven into the very structure of American law. We also see why legacy continues to echo, why that legacy of this white supremacy continues to echo today. If we want to understand the world in which we live, if we want to confront the truths of our history, and if we want to build something better, we have to face not just the brutality of slavery, but the ideology that sustained it. That is why these stories, these laws, these cases still matter today.